Hear ye. The Honorable Chief Judge Tabor and Associate Judges Bading and Sandy of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
Please be seated. Good morning and welcome to this 9 o'clock session of the Iowa Court of Appeals. We have 3 cases to hear. The first of those is Stephanie Schulte versus the State of Iowa. It's number 250051. For the appellants this morning, we have Molly Parker, and for the appellees, we have Holly Kissel. So thank you all for being here. Counsel, whenever you're ready.
May it please the court, counsel. The Iowa Supreme Court has made the jurisdictional requirements for exhausting administrative remedies under the Iowa Tort Claims Act clear. A claim is properly presented to the board when it identifies sufficient information for the board to investigate the claim and discloses the amount of damages claimed. Here, the state is not alleging that Stephanie Schulte failed to identify sufficient information to allow it to investigate her claims, nor is it alleging that she failed to disclose an amount of damages. But the state still maintains that Stephanie Schulte failed to exhaust her administrative remedies. The question before this court is twofold. First, did Stephanie Schulte have the capacity to exhaust the administrative remedies on behalf of her murdered daughter's estate? Second, did Stephanie Schulte, in fact, exhaust her administrative remedies as an individual? In addressing this question about exhaustion, courts have been very clear that the poll star of a determination about whether remedies has been exhausted is legislative intent. And once again, the legislative intent of the Iowa Tort Claims Act is clear. The purpose of the administrative process set out in Chapter 669 is to allow prompt investigation of claims against the state and facilitate early settlement when possible. In that vein, not every administrative regulation promulgated under Section 669.3 is jurisdictional in nature. Instead, the jurisdictional prerequisites for the Iowa Tort Claims Act are set out under Chapter 669.5. Segura versus State, decided in 2017, has a robust discussion of the differences between 669.3 administrative regulations and 669.5 jurisdictional regulations. That's good law that has not been overturned. And we've seen the court apply that difference between jurisdictional regulations and administrative regulations over and over again. We saw it in Allendorf versus Langman, where failure to include a sum certain while a violation of administrative regulations was not a violation of jurisdictional prerequisites. We saw it in Schneider versus Iowa, where a failure to respond to the state's request for more information was a violation of administrative regulations, but not of jurisdictional prerequisites.
Counsel, I'm going to interrupt briefly. I'd like to talk about the Anderson case if we could. And I'm quoting from Anderson specifically. It stated, "It follows that, generally speaking, the state can be liable to an estate even though the administrator filed tort claims before being appointed," which is what we have here. "But there is at least one important limitation to this principle. Suits filed prior to the administrator's appointment do not toll the statute of limitations," end quote. Help me. How does that not close the door to your claim entirely, given the fact that there was no estate opened at the time the letter was sent to the board?
Because there is a critical factual difference here. And that is, in Anderson and all the cases it relies on and the state relies on, there was no estate at any point during the administrative process or before the statute of limitations. And as a factual matter, that is not true here. It is undisputed.
But why does that distinction matter relative to the tolling of the statute of limitations? Help me bridge that gap. Why does that distinction matter?
because the estate was open during the administrative process. And it again loops back to the purpose of the Iowa Tort Claims Act and the purpose of the administrative process, right? The language in Anderson about capacity and the other cases is focused on the ability for the state to actually settle a claim with a claimant, right? Here, the state could have done that. Instead of being in a position where there was no previous estate to relate back to, there was an estate open.
How does section 633.489 affect your argument on that point? The last phrase of that statute says a claim that's barred, when you're reopening an estate, a claim that's barred can in no event be asserted in reopened administration. So this claim was barred when the estate was reopened, right, by the statute of limitations?
If you disregard the fact that the estate had been open before in looking at the timeline of events, you're right. I mean, I can't tell the court that the estate was reopened within the 2-year statute of limitations from the time of Lorena's murder. So that much is very clear. What Stephanie Schulte relies on is that this is a factually distinct and brand new pattern of facts that no court has addressed. And if we are true to the fact that the point of the Tort Claims Act is to allow prompt investigation and settlement, this is an importantly different fact pattern because Stephanie Schulte did have capacity to settle those claims. She had it during the administrative process when her first claim form was open, and that claim form was still pending when the second one was filed. The state knew everything it needed to know to settle, and they had the ability to settle with the appropriate claimant. And so while piecing together this timeline of events feels perhaps similar to some of the cases cited in Anderson, might feel similar to Voss, it really is importantly different. Because if we're focused on the state's ability to do its statutory obligation to investigate and try to settle appropriate claims, it had everything it needed to do that.
The records show why the estate was like inadvertently closed in this case.
I apologize, I didn't mean to interrupt you, Judge.
I needed, thank you.
No, it does not. But I think coming back to the precedent, I think it's important to distinguish that this is unlike the prior cases where an estate was at no point opened either during the administrative process or before the statute of limitations. The estate was open. It was open for over a year during the administrative process, and it's open again now. In that vein, there's no question that she had the capacity to file this lawsuit, right? A lot of the cases the state relies on are about the capacity to file a lawsuit. That's undisputed. She was the administrator of the estate at the time the lawsuit was filed. And so with respect to her exhaustion of her administrative claims in her representative as the estate representative, that is an important distinction. The state had everything it needed to settle this claim. And on that point, we think the Troster case is the most relevant, right? In Troster, the claimant or the petitioner had the capacity to file the lawsuit at the time it was filed. Then the estate was closed for a temporary period and reopened, right? At the time the estate was closed, that person had no capacity as administrator. But the Troster court said that temporary closure is not going to divest her of her capacity. And that lesson applies in these circumstances. That lesson applies to say, we're talking about a claimant who undisputedly had capacity as the estate representative, lost it temporarily, and had it again, all while administrative claims were pending. If we're focused on the language of the act and the purpose of the act, that should not deprive Ms. Schulte from her ability to pursue this claim. I do want to say a quick note about Ms. Schulte's individual claims and her exhaustion of those claims. As I mentioned before, courts have been very clear that administrative regulations are not necessarily jurisdictional prerequisites for exhaustion of claims. And here, requiring a separate form for Ms. Schulte to exhaust her individual claims would be the definition of putting form over function. There is no dispute that the state knew that she was making claims in her individual and her representative capacity. There is no dispute, and the district court found, unchallenged on appeal, that those claim forms had sufficient facts. There is no dispute, and the district court found, unchallenged on appeal, that those claim forms met the jurisdictional prerequisites, except for the fact that they weren't on a different form.
For a minute about the substance of those claims, at least the loss of consortium claims. Does Iowa even recognize a claim of loss of consortium for an adult child?
I think that's a question the district court would have to address.
And was that raised in the state's motion to dismiss?
I do not believe so, Your Honor, but I would need to double check. With respect to her individual claims, there is no case law requiring a separate claim form, and Ms. Schulte articulated independent claims within her filing. With that, I see my time has expired. Thank you very much.
I'm on rebuttal. Counsel?
May it please the court, counsel. My name is Hallie Kissel, and I represent the appellee, the state of Iowa. This case rises and falls on jurisdiction. Because the rules set forth in the Iowa Tort Claims Act are jurisdictional, failure to follow them is fatal. All parties agree that Ms. Schulte did not follow these rules, as she concedes in her brief that under a literal reading of the administrative rules, she was required to file one form for her estate claims and a separate form for her individual claims. She did not do so. Therefore, she never properly presented her individual capacity claims and never exhausted them. Separately, the estate claims fail because no one with legal capacity filed a valid tort claim before the statute of limitations expired.
First point, this case is a little bit different than Anderson, isn't it? In that if the estate administrator claims go away, all that's left on that claim form is the individual claims. So why couldn't that stand on its own?
Your Honor, I think that argument would fail because that would assume that we're doing a merits analysis at the jurisdictional stage, and we're not. So presentment under the Iowa Tort Claims Act is claimant specific, so each claimant must file a separate claim. And the Anderson court reaffirmed that, and Schulte, as an individual here, did not do so. And so I think the fact that her estate and individual claims were combined on one form means both could have been dismissed under Anderson. Trial counsel didn't pursue that, but since it's a jurisdictional issue, this court could decide that even though it wasn't raised to the district court. But again, that doesn't change the governing law, and jurisdiction doesn't depend on which defect the state chooses to press. Here, Ms. Schulte did not file a separate tort claim for her individual claims, and so she did not exhaust her administrative remedies. And so talking about the individual claims, again, she did not exhaust her administrative remedies, so for those individual capacity claims, so the district court didn't have jurisdiction. And the Iowa Tort Claims Act requires each plaintiff to file a separate tort claim, and Ms. Schulte didn't do so here. And I think if we zoom out and look at why, we need to start with the principles of sovereign immunity. A state can be sued only in the manner and to the extent that the legislature permits. And the presentment rules of tort claims define the conditions of a state's waiver of sovereign immunity, and those must be strictly construed, and that's from the Phelps v. State case.
Respond to opposing counsel's argument that there's a difference between the statutory requirements and the administrative regulation requirements, and the administrative regulation requirements aren't necessarily jurisdictional.
Your Honor, I think Anderson answers that question for us, and it says that the statutory rules must be followed, and there the legislature has given rules authority to the state appeal board to create these rules. And so even when we look at the statutory rules and the rules that the state appeal board has created, it says that there must be strict compliance with the procedures. They're not technicalities. They define conditions of the state's waiver of sovereign immunity. The Iowa Administrative Code Rule 543-1.41 says a separate claim shall be filed by each claimant. And the SAB's own form also repeats this requirement, saying a separate claim must be filed by each claimant. And Anderson confirmed in that rule is mandatory and jurisdictional. So I think this court would just need to look to Anderson to see that the statutory rules as well as the administrative rules are mandatory and jurisdictional here. And so again, Ms. Schulte never filed a separate form for her individual claims. Both claim forms list multiple claimants on a single form. And she doesn't contest that she didn't file a separate form. She just asked that there be an exception here to the rule. But the result is that she never invoked the state's waiver of sovereign immunity for any individual capacity claims. And also the separate claim requirement is jurisdictional and it's not subject to notice or waiver. Iowa law forecloses all of Ms. Schulte's notice and fairness arguments. Presentment is not a notice doctrine. It's a statutory prerequisite that again was made clear in Anderson. It is part of the plain text requirements that plaintiffs must follow to take advantage of the state's partial waiver of sovereign immunity. Courts lack authority to excuse noncompliance for fairness or actual notice, and this court can expand jurisdiction beyond what the legislature has laid out in the statute and the rules. And Anderson again said that the plaintiff must follow the Iowa Tort Claims presentment requirements, even if, as a practical matter, it would not have changed the state's handling of that case. And they're quoting the Bloomingquist v. Wapello County case there. So the case law tells us that the question is not whether the state understood that Ms. Schulte had individual claims, but whether she filed a separate tort claim in the form and manner prescribed by the law. And here she did not do so.
The waiver of sovereign immunity, like counsel talks about it being form over substance. How is it really not that? Like if we had a member of the public and we're trying to say like, well, you didn't use two separate forms here. Like as a practical matter, why are we going this direction?
Your Honor, I think it's because fairness here would come from a consistent application of the rules. And so both claimants and the state need to know what the presentment requirements are and trust that they will be applied consistently in each case. And so this isn't about form over function, but it is the structure that the legislature has laid out for when the state may be sued. And so Anderson makes clear again that difficult facts don't allow courts to waive these jurisdictional steps. And so the court can't cure Ms. Schulte's defect here.
It can be read differently, though, because if I recall, there's two different individuals there, right, on one form, as opposed to the individual and the estate administrator.
Yes, Your Honor, I believe there is a factual distinction, but I think that actually bolsters the state argument here. And so, as you said, in Anderson, it was just one claim form with the estate, and then when it was brought to the district court for the lawsuit, they tried to add individual claims. And so I think there, the court would have had an easier route to say, well, the appeal board or the state never had notice because those individual claims weren't even listed on the form. But they didn't do so there. They actually rejected a notice sort of standard and said an individual claim must be filed on a separate form, and here that wasn't done. And so I think the factual distinction actually bolsters our argument in saying separate claim forms must be filed, and that didn't happen here for the individual claims. And I want to turn briefly to the estate claims issue, and those also independently fail. A valid tort claim requires a claimant with legal capacity. So under 669.23a and Anderson, a claim is valid only if the state could be liable to the claimant, and only a personal representative can sue on behalf of an estate. So a claimant must possess legal capacity during the presentment process. And again, Ms. Schulte talks about the purpose of the rules, which is to allow a prompt investigation of claims against the state and facilitate an early settlement when possible. But the state can't settle with someone who doesn't have legal capacity of an estate. A closed estate has no legal existence, and so the purpose can't be met when an estate is closed. And here the estate was closed, and Ms. Schulte had been discharged as administrator when tort claims 2 and 3 were filed, which is all that is before this court. So there was no representative, and therefore there was no capacity and no valid claimant. So the claim was void the moment it was filed. And as Judge Sandy notes in Anderson, there is an exception to the general rule, which is that a representative may bring claims on behalf of the estate before they are appointed. and then after the appointment, they can ratify those pre-appointment acts. But there is an important limitation to that exception, and that is that capacity defects may be ratified only if ratification occurs before the statute of limitations has expired. And here, ratification came too late. The statute of limitations had expired.
Isn't as clear as you're stating it, is it? It doesn't. It talks about statute of limitations and not being able to skirt that, but it doesn't like sort of put the point at ratification. And we do have, if you relate back here, it was clearly before the statute ran.
Well, Your Honor, I think that if we're looking at Anderson, then we also have to look at the estate of Dyer case, Pearson, Gardner as well. And those cases make clear that no relation back can toll the statute of limitations. And so here, when estate or tort claim 2 and 3 were filed, the estate was closed. I believe, let's see, March 23rd, 2023, the statute of limitations ran, and then April 17th, 2023, the probate court granted Ms. Schulte's petition to reopen the estate. But then this tort claim wasn't, or this suit wasn't filed until January 9th, 2024. And so the statute of limitations can't be, I guess, kind of skirted around under the case law, even looking at other cases beyond Anderson here. And I see my time is out, but the state would ask that the district court be affirmed in full.
May it please the court. Counsel. Anderson respectfully does not address the questions posed in this litigation squarely. As an initial matter with respect to the individual claims, Anderson is very clear. The claimants there did not even attempt to make an individual claim on their tort form. That's an entirely different world than we're in here. Here, it's undisputed that Stephanie Schulte made claims listed as administrator and individual capacity. The Anderson claimants did no such thing. Anderson is not on point on that issue. Furthermore, the state's emphasis on Anderson as opening up the administrative requirements to be jurisdictional is flatly wrong. Segura is very clear. Promulgated administrative rules under 669.3 are not the same as jurisdictional requirements under 669.5. And if we're talking about the requirement to file a separate claim form, that requirement is wholly absent from both the form itself and the statute. The statute requires filing a separate claim, and it defines claim as a cause of action against the state. Nowhere on the form does it say you must submit this form separately for each claimant. Nowhere in the statute does it say you must submit a separate pile of paperwork for each claimant. The statute requires that you submit separate claims. And Stephanie did that. She listed the claims separately. She broke out her wrongful death claims from her IIED claims and her loss of consortium claims. Those things are important. The state does not have any basis to argue that each one of the administrative regulations it promulgates under 669.3 is jurisdictional. It's just not. We've seen that over and over again in the way that the courts have handled the administrative formulaic regulations like having it, whether it can be signed or not. And the state's reliance on Bloomquist, I would just note, if anything, Bloomquist is a case where a mother did not exhaust administrative remedies because she did not include her children's loss of consortium claims. That discussion was including whether she included them on her tort claim form. If anything, Bloomquist teaches that you could exhaust multiple claims on a single form if it's clear what the claims are. And I want to just end with reading this quote from McFadden because I think it drives at the heart of what we're talking about here. Rights must not be denied by too strict an application of mere legal formality. The sword of justice is not often made more keen by the whetstone of technicality, and a right secured by too rigid means may harden into a wrong. Not only must justice appear to be done, but it is the function and duty of this court and of all courts to see that it is done. Technicality should not become a Pegasus, which, if ridden by an expert legal jockey, may carry us far away from the true goal. That is what the state's argument is. The goal here isn't justice, the state's ability to resolve a meritorious claim early through settlement. The state's argument is that this court should turn the Iowa Tort Claims Act into the enforcement of a checklist, and that is the definition of a nettlesome hurdle, the exact thing that courts have warned time and time again. The Tort Claims Act should not just be a burden for claimants to trip over. But that's exactly what the state is asking this court to do. That's contrary to the case law, it's contrary to the statute, it's contrary to this court's well-established precedent. If we are at all serious about legislative intent being the pole star of our interpretation of this statute, the administrative regulations cannot be jurisdictional. And if they are, then we are no longer using legislative intent or purpose as the pole star. For those reasons, Ms. Schulte respectfully requests that this court reverse, find that she exhausted her administrative remedies, and remand to the district court for further proceedings. Thank you.
Thank you to both counsel for your really helpful, effective arguments today. A written decision will be forthcoming as quickly as we can, and we will consider this case submitted. Thank you. The next case on our docket this morning is Gregory Herrick and Jane Evans versus 21st Century Farms. Good morning. This case is 250377. We have Mr. Nicholas Miller for the appellant and Michael Bull for the appellees. Mr. Miller, whenever you're ready.
Good morning, Your Honors. May it please the court, Mr. Bull. Thank you for the opportunity to be heard today. I'm Nick Miller. I represent Greg Herrick and Jane Evans, the minority shareholders of 21st Century Farms Limited, who brought claims for minority shareholder oppression and breach of fiduciary duty, ultimately seeking a dissolution of the company. The district court dismissed those claims, and this court should reverse and order dissolution of the company. The hallmark of minority shareholder oppression under Iowa law is the majority's frustration of the minority's reasonable expectations. And courts in Iowa, including this court, have found oppression proved when the effect of the conduct of the majority shareholders deprives the minority shareholders of any return on shareholder equity.
A bit of a foundational question. Does this case offer sort of the possibility of some fluidity between who are the majority shareholders and who are the minority shareholders? It seems like the brothers kind of vote in a block, but that wouldn't necessarily be the case all the time.
Conceivably, Your Honor, the record, however, establishes that the two majority shareholders here, Tom Evans and George Evans, voted in lockstep all the time. So effectively, what we have here is a majority voting block from Tom and George Evans to the detriment of the minority shareholders here, who are Greg Herrick and Jane Evans. The record...
All the shareholders vote in lockstep for the majority of time that the corporation was running. I mean, 37 years of unanimous decisions.
On various issues, Your Honor, yes, there was some voting, but as soon as, I would say, going back to 2017 and possibly before that, when Mr. Greg Herrick and Jane Evans started asking questions about any return on their shareholder equity, it was at that point forward that there was a divergence in the voting. And during trial, I believe Tom and George Evans both testified that generally, yes, they tended to vote together. There's a portion of our appellate brief that I'd point you to as well, where in one of these shareholder meetings, the George or Tom Evans is presiding, and neglects to even ask the minority shareholders, Greg Herrick and Jane Evans, how they were going to vote, because in his mind, he knew what reality was. It was a foregone conclusion that whatever Tom Evans and George Evans wanted to do was going to be done. So conceivably, Judge Tabor, yes, there could have been some fluidity, but the record establishes that there just absolutely was not. Now, going back to my election point, Greg Herrick and Jane Evans proved minority shareholder oppression and breach of fiduciary duty in this case. They proved that after forming 21st Century Farms, that they formed 21st Century Farms for the specific purpose of purchasing farmland at a foreclosure auction, and that after that, there was only one dividend issued after
Dividends to be issued?
It's one way, Your Honor. There is sometimes a demand made by a particular shareholder for dividends. The fact that's most important here, Your Honor, is the fact that there was only one dividend issued in 30 years, coupled with an appreciation in the value of the farmland held by the company and an accumulation of rent revenue, that the company in no way ever returned anything to the shareholders for that. For 30 years, the company was accumulating cash, the land value was appreciating, yet the shareholders were not realizing any return. No dividends, no nothing.
Piggyback a little bit off Judge Bading's, but isn't it a little bit premature to argue shareholder oppression here? Because there wasn't repeated requests for dividends, there wasn't repeated requests for buyouts. When you compare it to like what happened in the Bauer case, there's really, I think it's just that February meeting where it kind of comes to a head.
Agreed, Your Honor, that there was not, I apologize, a repeated formal request for either dividends or a buyout. But going back to 2017, Mr. Herrick and Ms. Evans started asking to be bought out of the company. In fact, Mr. Herrick and his accountant made different proposals for ways to be bought out. Mr. Herrick even personally offered to self-finance a buyout. They were trying to find some kind of solution to realize some kind of value in their equity in this company. Unfortunately, the majority shareholders would not allow them to do that. They did not want to hear any proposals. They were not interested in proposals to be bought out. So although there is a lacking formalistic demand letter style demand for dividends and to be bought out, there is a pattern of both Mr. Herrick and Ms. Evans asking to be bought out. And the context, for more background there, is that Joe Bauer is one previous shareholder who was bought out by the company. And the way that they did that was they got 3 different appraisals for the farmland. One was secured by the majority shareholders in the company, one secured by Mr. Bauer himself, and then one by a third party. They used those to then value the shares, and Mr. Barr was bought out. So in that, there is context for a shareholder, a minority shareholder being bought out in the company, and that was what Ms. Evans and Mr. Herrick were using as context for their request to be bought out, is that there was a history for this.
Circumstances surrounding that buyout being that it was the son-in-law that was divorcing the daughter. The father, I think, kind of encouraged him to not be a part of the operation anymore.
That is some background context for that, Your Honor, but I'm not certain that that entirely matters, because the relationship in this situation has similarly broken down. And what the majority shareholders did for Mr. Barr was buy him out. And they had a process for that, which was getting those 3 appraisals. Now, they've expressed absolutely no desire to want to do that for Mr. Herrick and Ms. Evans. So effectively what we have here is whatever they want. When they feel like a relationship has soured, if there's no value in it for them, they may buy you out. But if there's not, they're going to let you suffer. There will be no return on your shareholder equity, and you'll be stuck in this company indefinitely.
I have 2 questions. The first of which is, was there actually ever an offer by Greg or Jane to sell their shares to the corporation?
With specific definitive terms and dollar figures, Your Honor, I cannot cite you to a point in the record where they did do that. However, there were express requests to be bought out generically and different proposals for how to get to that point, Your Honor. Unfortunately, when they made those proposals and when they were making those requests, they were met with obstinance. They didn't want to discuss.
Maybe this is a glib question, but one I'm curious about. There was nothing that stopped Greg and Jane from selling their shares to any third party, was there?
That's correct, Your Honor. There's nothing either in the bylaws or in Iowa law that would technically prevent them from selling to a third party. However, no third party would ever buy into this company because the only thing that Greg and Jane can ever offer to them is a minority shareholder interest, and no educated third party is going to buy into that type of a company.
Right, but underlying that question is this: is it a reasonable expectation that the minority shareholders get bought out with whatever formula they want from the corporation itself? I mean, they do have an exit valve. It might not just be as financially beneficial as they'd like.
I think they have a theoretical exit valve, Your Honor. It's not a real one. No one would buy into this company. No third party would buy into this company. The majority shareholders are not willing to buy their shares, nor will they allow the company to buy their shares.
Do we know in the record the majority shareholders were not willing to buy the shares? Because I was just remembering the minutes from that February meeting, and there was some mention of selling to the majority shareholders.
I think if you review the record, Your Honor, that there may be comments and discussion about the fact that Greg and Jane had been demanding that they be bought out, but at no point is there ever an indication from the majority shareholders that they are going to buy them out or that they will be willing to vote in favor of having the company buy them out.
But also not a refusal of the majority shareholders to buy them out.
Not an outright, we'll never do this, we're expressly stating on the record. I don't think they would ever do that. I'm dwindling on my time here. I want to make one critical point that I think is really important, which is the district court misapplying the legal standard here by incorrectly emphasizing the majority shareholders' subjective expectations rather than the minority's expectations and whether those expectations were objectively reasonable. The majority shareholders testified themselves at trial that their expectations and desire was simply to maintain the family farm and accumulate cash to purchase more land, notably a plan that yields no return indefinitely. That was their testimony at trial from the majority shareholders. They do not intend for any shareholder to realize a return on their investment.
Thank you, Counsel, and you'll have more time on rebuttal. Mr. Bull.
Thank you very much, Madam Chief Judge. Panel, may it please the court and counsel. I represent the appellees in this case, Dr. Tom Evans and Dr. George Evans. This court should affirm the ruling of Chief Judge Gookin below. Greg Herrick and Jane Evans, who I will respectfully refer to as Greg and Jane throughout this argument, did not come close to meeting the basic elements of a minority shareholder oppression claim as defined in Bauer. As the court has recognized, this is a buyback type oppression claim, and that has very clear elements. The district court considered these arguments. They considered the testimony of all four shareholders, the testimony and the credibility of those shareholders, the evidence in the record submitted at the time of trial, and the trial court made several significant conclusions. One being, as this court has picked up on, at no point were there ever any formal offers or demands for Greg and Jane to sell their shares to the corporation at any value, much less fair value.
I agree that that's the case, but also in the minutes from that February 2023 meeting, there's a fairly definitive statement that representing the majority ownership, Tom and George state that the corporation is not buying any shares. Is there any point to make offers at that point when you have we're not open to accepting them?
I think, Your Honor, you've hit on the point of this case may be a bit premature for corporate dissolution. So in the context of dissolving this family farm corporation, I do believe there is more that needs to be made for two reasons. One, because Bauer does require repeated offers to sell for shares, and point number two, at fair value. What Greg and Jane are wanting here, what they're exploring tentatively here, is the sale of shares for something above fair value. That goes to the other very important point that Chief Judge Gookin made, which was that although Greg and Jane did not attempt to explain at trial or here today what the value of their shares are, it necessarily exceeds fair value, as is required by Bauer.
Why is that? Can you explain that to me?
Absolutely, Your Honor. I think the bar methodology as was described today would be 3 appraisals, and then the parties kind of either reach the middle or the average appraisal of the land divided by the interest of that individual shareholder. Well, we know at a minimum that fair value takes out transaction costs and the cost of sale. So no matter what that value would end up being, it is more than fair value.
Even if a sale is not imminent?
Under the Googe decision, there is the subtraction of transaction costs, real estate commissions, no matter whether a sale is contemplated or not. Now, at trial, there was a fair value analysis introduced and accepted by the court by Tom and George, which also took into account tax consequences. We believe that is the case, to take into account in this C corporation that's always been a C corporation, the tax consequences of a sale. I realize that in the Googe case, and there's been some discussion of whether tax consequences should be included. The court does not need to reach that decision, and in any event, Greg and Jane did not provide any expert testimony or any valuation of the shares, which means, in my opinion, they have essentially waived any argument, excuse me, that tax consequences should not have been factored into the fair value.
The oppression inquiry looks at whether the corporation has the financial resources available to do the buyout. When we're examining that question, are we looking at just the cash holdings of the corporation? Are we looking at the value of the farmland? How do we evaluate that?
I believe it is the cash value and also the value of the farmland. And there, Chief Judge Gookin, I think at page 17 of his order, did the best he could with the record that was brought by Greg and Jane to say, here is the value of the corporation and the value of the assets that they have. Here is what I believe the fair value of their shares would be using Tom and George's analysis. And the corporation would be $636,000 short of being able to facilitate a buyout.
Greg and Jane's hypothetical request at trial, how about that? Did it take into factors relating to marketability or minority status discounts on what they were wanting as well?
I believe it did. I would defer to the appellants on that point. I believe that the fundamental question of why the court doesn't need to reach those fair value determinations is because Greg and Jane throughout, again, tentatively speaking, were seeking something above fair value. They were seeking the bar valuation, whatever that is. Practically, evidentiarily, factually speaking, they didn't even follow the bar methodology. We didn't have appraisals done. We don't know what that number is. So regardless of what a fair value would be, we know that, one, Greg and Jane are demanding far more, which is why the business is not required to consider that under the business judgment rule. And number two, the actual determination of fair value in this case is not as particularly important, frankly, given the premature claims that have been raised by Greg and Jane.
How many acres total are we talking?
There are approximately 560 acres in the corporation as it stands right now.
And what are Greg and Jane's combined total shares?
Their combined total shares, Your Honor, are 97.5, which is approximately, I'm doing the math in my head, I apologize, Your Honor. It's less than half of the Jane owns approximately 14% of the corporation. Greg has approximately 28.6% of the shares of the corporation as it stands.
So do you agree with opposing counsel's assertion that there's just no market for what would be, I don't know, maybe a third or 40%, let's say, of 560 acres of farm ground?
Tell. There's no evidence in the record documenting any attempts to sell the land. I think, Your Honor, the point you made earlier today was exactly right, which is that they do have an exit strategy. It might not be one that they prefer, but it is something that they could explore. There was certainly no evidence that Chief Judge Gookin considered that would have reflected that. I also think when there's a fundamental difference between whether they have a good exit strategy and whether a Bauer claim requiring dissolution of a corporation is the proper remedy. And I think overall, Your Honors, the Bauer case, I think, sets an extremely high standard for when corporate dissolution is the appropriate remedy. The Bauer court set very clear requirements as to when dissolution can be considered, when an oppression case has been successful. The plaintiffs did not meet that in this case. for three reasons. As one, as the court mentioned, there are not corporate assets to facilitate a buyout. To do so, the corporation would either have to incur debt or sell off farmland, which runs directly contrary to the purpose of the corporation. There's been no effect on the reasonable expectations of Greg and Jane for a buyout of this nature that they're sort of requesting or sort of prematurely alluding to.
District Court focus enough on those minority shareholders' reasonable expectations as Bauer requires, or did it, as counsel suggested, go too far to look at the majority shareholders' expectations?
I don't think so. Your Honor, respectfully, I think that concern about it being the subjective expectations of some shareholders versus others, I think that's a collateral attack on the judge's credibility findings. The judge made credibility findings. He heard from all four shareholders in this case. Chief Judge Gookin, I think quite intentionally, wrote in his order that the court had, quote, carefully observed the witnesses at trial and factored observations into assessing the credibility of each witness and the weight to be given their testimony. Chief Judge Gookin heard from all four shareholders, and our courts have said that in assessing reasonable expectations, you need to assess the minority's expectations against all other shareholders. I think that's important. Also important to note that the court looked at the corporate's founding documents, its 37-year history, its history of acquiring acres. There are 560 acres now. 60 of those were purchased after the original formation of the corporation. The court looked at all of those things and then ultimately did determine that the purpose of the corporation is something other than a moneymaker, something other than an investment vehicle, where any minority shareholder can just cash out on whatever terms they like, or terms that were used once 20 years ago.
What is the exit strategy? If we set aside the ability to maybe sell to a third party, how will the plaintiffs ever be able to make a return on their investment? Because the court found that was a secondary purpose of the corporation, right?
Yes. That's exactly right. I mean, by engaging in a discussion about a proper exit strategy, right now, all of the conversations up to the point of the lawsuit being filed were incredibly tentative, maybe selling additional acres to the corporation, maybe not, maybe something in between. I think an actual genuine discussion about what is the fair value of your shares and is there interest in the corporation financing any of these routes. It's the corporation's, it's the responsibility for the corporation to act in its own best financial interest. Part of that is not oppressing its minority shareholders, obviously, and part of it is making sure that the corporation continues to exist and can pay its bills. I only have a little bit of time remaining. I believe if there are no further questions, I will sit down. Thank you very much.
Thank you, Your Honor. I want to revisit an important critical fact that I'd spoken about during my opening argument, and it's that the testimony from the majority shareholders here conclusively proves that the majority intended to prevent any return on shareholder equity. In their view, the whole purpose of the company is to hoard farmland for the sake of hoarding farmland. They testified that they, one, never intended to sell any of the farmland, and two, that the whole purpose was to not only accumulate cash, but to buy more farmland. So the testimony from the majority shareholders themselves is that, indefinitely speaking, there will be no return for any shareholder. On top of that, Your Honor, Mr. Herrick and Ms. Evans had been making informalistic demands to be bought out because they were realizing exactly that for an indefinite period of time, they would not be realizing any return on their shareholder equity. And in fact, the majority shareholder, Tom, dared Greg and Jane to take legal action because it would effectively drain the company's resources. In other words, the majority shareholders told the minority, we have you right where we want you, in a catch-22. You can't get out, and if you try, you're only going to be hurting yourselves. That fact, their testimony, plus that, it just shows their subjective intent here, which is to oppress. We've talked so far about what a lot of objective facts indicate and what we can infer from them. I think we need to look directly to the majority shareholders' testimony in this case, which is illuminating.
Paused. Can you tell me whether there's any daylight between your breach of fiduciary duty claims and your oppression claim?
Exactly where I was headed next, Your Honor, because I want to address a couple of critical facts that speak to that as well. Number one, the majority removed Greg and Jane from the board of directors in plain violation of the corporation's bylaws. In April of 2024, the majority voted to reduce the number of directors from 4 to 3, which they believed would drop Greg and Jane from the 4-member board and allow them to immediately elect their preferred person, Tom's wife. This, without dispute, violated the company's bylaws, which state that a reduction in the size of the board does not end current board members' terms, and that the reduction is only effective at the next annual meeting. So when they did that in April of 2024, Greg and Jane's terms on the board of directors did not actually end until January of 2025. The majority shareholders did not care. They removed them from the board, did not let them participate, and put Tom's wife on the board. That's a breach of fiduciary duty because it is an express violation of the company's bylaws. They knew it and they did it anyway because they wanted them to have no influence on the company.
The additional evidence to the reopening, or was that in the original information in front of the court?
That was in the original record, Your Honor, but the evidence submitted with a motion to reopen added to that. It also added to this other point, which goes to the reimbursement of the majority shareholders' fees. And to your earlier question, Judge Batting, that goes to the breach of fiduciary duty claim as well, because what we have here is self-dealing. Now, the Iowa Business Corporations Act allows for corporations to reimburse officers and directors for their personal attorney fees if they're sued for something done in their official capacity working for the company. Makes perfect sense. It does not provide for shareholders, let alone majority shareholders, to be reimbursed for their own personal attorney fees. The majority shareholders in this case were sued in their capacity as majority shareholders, yet they reimbursed their own attorney fees anyway, depleting the company's resources and in keeping with exactly what Tom said, which is, if you sue, go ahead. You're going to hurt yourself because you're a shareholder, and we are going to deplete the company's resources. That is a breach of fiduciary duty, no questions asked. With that, Your Honor, I see that I'm running out of time, and in sum, we would ask the court to reverse the district court's decision dismissing both the claim for minority shareholder oppression and the claim for breach of fiduciary duty and order a dissolution. Thank you.
Appreciate both of your thorough and responsive arguments today, as well as the good briefing in this case. We will consider Herrick versus 21st Century Farms submitted, and we'll have a written decision as soon as we can. Thank you. And we're ready for the case of State versus Noll. State versus Noll. It's 250096. For the appellant, Mr. Noll, we have Katie Sears. And for the appellee of State of Iowa, we have Olivia Brooks. Ms. Sears, whenever you're ready.
May it please the court? My name is Katie Sears, and I'm representing the appellant, Mr. Richard Noll. This case presents two significant constitutional questions. First, Deputy Walker performed an illegal pat-down of Mr. Noll. That pat-down was illegal because Deputy Walker did not have reasonable suspicion that Mr. Noll was presently armed and dangerous. He never claimed he suspected that. There's no evidence supporting that, so he wasn't allowed to do that. The pat-down was quick, but it still measurably extended the duration of the stop. And officers don't get free time during traffic stops to conduct unlawful pat-downs. Under Rodriguez and Arrieta, any extension of the stop is unconstitutional unless it's independently justified by reasonable suspicion that would justify expanding the scope of the stop. Second, Deputy Walker later searched Mr. Noll's person a second time. It was during that second, more intrusive search that he found the methamphetamine underlying the conviction in this case. And the state now seeks to justify that search as incident to arrest. But at the time of the search, Deputy Walker had not arrested and was not in the process of arresting Mr. Noll for anything.
Our first decision in this case on the remand, limiting the court to determining whether it was a search incident to arrest, or could the court have examined that search under other exceptions to the warrant requirement?
I'm not sure what the court intended. I suppose had the district court been so inclined, they could have expanded and explained their ruling on other grounds. I don't think they explored that really.
But the district court on the remand looked just at the search incident to arrest exception.
Yes. So a search incident to arrest is dependent first on an actual valid custodial arrest. And as State v. Stevens favorably quoted a Maryland case, Wallace v. State, probable cause to believe that a person is carrying evidence does not justify a warrantless search of the person, any more than probable cause to believe a house contains evidence justifies a warrantless search of the house. At its core, the state's argument appears to be that officers may search whenever they have, or whenever they believe they have probable cause that could justify an arrest. That's dangerous, and it's disallowed under controlling precedent. Iowa courts have previously attempted to extend the search incident to arrest doctrine to include searches incident to citation. Under Iowa Code Section 805.1 sub 1, an officer can issue a citation in lieu of arrest anytime he has probable cause that could justify an arrest. And Section 805.1 sub 4 provides that issuing a citation does not affect the officer's authority to conduct an otherwise lawful search. So in State v. Meyer, the Iowa Supreme Court read those provisions together to allow searches incident to arrest whenever an officer issued a citation. But then the Supreme Court of the United States in Noll's held that no, that went too far. They said that Iowa cannot authorize searches incident to citation. Probable cause and a citation is not enough. So probable cause without a citation is not enough.
The state's argument today, their belief is that the deputy had probable cause to arrest Mr. Noll for operating under the influence, even if that wasn't articulated at the time of the search. Do you think the evidence the deputy had found up to that point would have justified it? There was some erratic driving, I think, driving well below the speed limit, weaving within the lane, some evidence of the Mr. Noll's response to the deputy at the scene, smell of marijuana. Was that enough to get them to the OWI arrest?
No, I absolutely don't think it was. And we cited a number of cases in our brief under which weaving in a lesion, let alone probable cause. He definitely did not have any basis to believe he was under the influence of marijuana. He claimed he smelled marijuana in the truck, not on Mr. Noll's person. He searched the truck. He didn't find anything. There also was no, and it came in over trial counsel's foundation objection, there was no foundation that Deputy Walker could identify the smell of marijuana. He testified that he could differentiate it from cow manure, but he didn't establish anything beyond that.
What about the fact that, as I understand, Mr. Noll was operating a motor vehicle with a restricted license, requiring an ignition interlock in his car, yet when he was pulled over, there was no ignition interlock in his vehicle. Is there any notion that that in and of itself is an arrestable offense, such that why are we talking about OWI and all this? I mean, isn't that a full stop after that?
So thank you for asking. As far as I can tell, driving without an interlock when you're supposed to have an interlock could be a contempt. And I'm not super clear on whether or not an officer can make a warrantless arrest for that. Contempt proceedings are quasi-criminal. There was no warrant for that. And at any rate, he didn't arrest for that. Under section...
Wouldn't it be driving while suspended?
No, I don't believe his license was suspended.
So a restricted license provision on a license, if you're driving not in conformity with that, that wouldn't subject you to driving while suspension?
the answer to that is, I'm sorry. Either way, under section 804.14, the police officer is supposed to inform the person they're arresting of the reason for arrest. And under D-Ray, USB D-Ray, it is the officer's responsibility to know what he is arresting for and why.
So on that point, if we find that there was probable cause to arrest for OWI, but the officer, after finding the methamphetamine, told the defendant, I'm arresting you for possession of methamphetamine, how does that affect our analysis? Is your argument that the officer can't change the reason for arrest based on other evidence found after the search?
I'd like to clarify your question. Are you saying if he was, you said he had probable cause for OWI. Are you asking if he was arresting for OWI?
Say that, the cases say that if you have probable cause to arrest, right, then you can make the search, not necessarily contemporaneous with the arrest, but even, after, contemporaneous or after. So if we find that the officer had probable cause to arrest for OWI, doesn't that validate his search?
Not. So the officer has to actually be conducting an arrest for OWI. Probable cause that he is not effectuating with an arrest does not justify a search incident to arrest.
Do you have a case? Is there any case that fits within these facts where, maybe the officer had probable cause to arrest for a different offense than he actually arrested the defendant for after the search?
Well, I think the closest is going to be, Rabinowitz flat out says search incident to arrest is dependent initially on there being a valid arrest, not just probable cause. There are, Chambers v. Maroney says that only in exigent circumstances will the judgment of the police as to probable cause serve to justify a search of a person. And this is not an exigency case. And then under Knowles, if search incident to citation, and a citation requires probable cause, doesn't justify search incident to arrest, then I'm not sure how you could possibly justify searching someone with probable cause without the citation.
Okay, thank you.
There's a bright line rule requiring the actual valid custodial arrest before the exception applies. And with that, if there's no further questions, I'd save any time for rebuttal.
Counsel.
May it please the court, opposing counsel. This court should affirm the district court's denial of Mr. Knoll's motion to suppress. The deputy's search of Mr. Knoll's person was a valid search incident to arrest, and the deputy gained no new information from his pat-down of Mr. Knoll, nor did it prolong the stop beyond the mission of the stop.
Was Mr. Noll under arrest, and what was he being arrested for?
Yes, when we look at the videos of the dash cam and the body cam, the time of arrest there, I think, is the beginning of the search of his person. When we look at cases like Harvey and Bradford, they discuss that it's this clear deprivation of liberty. So the arrest of arrest there was for OWI. In that search, he then found the methamphetamine. Now, certainly to the formal arrest, what I mean by formal arrest is when the officer said, now you're under arrest and handcuffed. That too can be the arrest and the searches before that as well. But I think that when we look at the body cam and the dash cam, look at the officer's conduct, when that search began of his full person, the officer was arresting him for the OWI probable cause.
Can we have probable cause for OWI when the officer did not perform any field sobriety test before making that arrest?
I think so, and I think when we look at the specific conduct that the officer observed when driving, that being, traveling well below the speed limit, crossing the center line, weaving within his lane, the late hour, that combined with his later observations of smelling marijuana and the open beer can, and as well as noticing that he was required to have the ignition interlocked but didn't have it at the time.
search occurred, the smell of marijuana and the open beer can, our record doesn't show that those were verified as, that the beer can was currently an open container. I don't see that in the record in the testimony. And the smell of marijuana, there wasn't any marijuana found, right? So that would sort of detract from any probable cause to arrest for the OWI?
I don't believe that is correct, Your Honor. And I think looking at the beer can first, whether there was an amount of liquid or alcohol in there would be a question probative to beyond a reasonable doubt for guilt of that. We don't need to show probable cause to the same level as beyond a reasonable doubt. So the beer can in the cup holder within reach of the driver certainly is a fact that the officer can consider for operating while intoxicated.
The deputy didn't testify to any other indicia of alcohol consumption, right? Like no smell, nothing before the supposed arrest for OWI.
That's correct. I think the officer was investigating OWI likely for marijuana, but it's also possible for alcohol given the ignition interlock and the beer can. And so I think those two things, we don't have to say exactly what substance it is that we're investigating for the OWI for that probable cause to exist to arrest. So the officer believed it was alcohol, maybe it was marijuana. Both of those things would be sufficient for that probable cause finding. But to your question about the fact that there was no marijuana found in the car, we aren't looking at what the officer later learned, we're looking at what the officer knew at that time. And I don't think that we can look at the fact that nothing was found to disprove the district court's findings that the officer had no, I believe that...
Right? Like they determined that nothing was found before the search.
Yes, that's correct. And the officer, though there was no...
That basis for the OWI arrest before they searched the person, his person.
Again, I don't agree with that because I think there are plenty of circumstances where the substance could be consumed and therefore no longer present in the vehicle because...
Not testimony that they smelled it on Mr. Noll.
The smell of marijuana, the officer said, was limited to the vehicle. So although no marijuana was found physically in the vehicle, the officer did reaffirm that he did continue to smell marijuana throughout the vehicle during the search.
Counsel, just taking the OWI out of that, and maybe I'm being too hypothetical with facts that don't exist, but I mean, even if the officer had no suspicion of impairment, could he not still be arresting the defendant for the mere fact that he's operating not within the confines of his license? I mean, what's he supposed to tell him to do? Hop back in the car and drive illegally back to your house after I just caught you not having an interlock device in your car?
I certainly can understand that question and that concern, although I didn't look into whether the ignition interlock is an arrestable offense on its own. As we outlined in the state's briefing, that the visible beer can in the open container is an arrestable offense. Now, to the question about arresting for OWI, and if there was, probable cause for one offense, but then later arrested for another offense. State v. Bradford, an Iowa Supreme Court from 2000. In that case, the officer was investigating a harassment call, and he was later patted down and searched, and controlled substances were found. In Bradford, the court said that there was probable cause to arrest him for harassment. He was not charged with harassment. He was only charged with the controlled substance violation. I don't think that we're breaking new ground in talking about this substantially contemporaneous search and arrest context. There are several cases where the arrest is after the search, and the court finds that it is substantially contemporaneous, so that it is a search instant to arrest. There are also situations where, like that Bradford case that I was mentioning, where the search happens and the court finds that that search within itself is the arrest because of that substantially limited freedom of movement, and the deprivation of liberty becomes that arrest.
Effectively, though, if you listen to the tape, the deputy talks about after finding the methamphetamine that that's what he was being arrested for.
I do recall that moment in the video, and I don't think that he's saying, I'm only arresting you for this. I think that we can look at the context of that question and as a recency answer, or perhaps even the officer is saying, when he's asking, what are you arresting me, or why am I being arrested, or something to the effect, and he's incredulously saying, dude, I found methamphetamine in your pocket. So I don't think that that is ruling out him also telling Mr. Noll at the window, I saw you swerving, I saw you crossing the center line.
Or investigation to the standard field sobriety tests after that. So the investigation on the OWI continues.
That is correct. The field sobriety tests do happen back at the station. And though I don't want to hang my hat on this, I do think that it at least moves the needle that in the the implied consent agreement, the officer does put on there that the time of arrest is 11:40, and that's around the same time that the search of his person is happening at the scene. So for the implied consent, the arrest for the OWI in their Exhibit 2 does, in the suppression hearing, does note that that time of arrest for the OWI 2 happened at the scene.
Counsel, was there any impairment investigation prior to the search of the vehicle? Do you know what I'm asking? You know, questions about, you know, when's the last time you smoked marijuana? Do you feel the effects of it? Would you mind submitting to some field sobriety tests for me? Was there anything related to that prior to the actual search of the vehicle?
Recall off the top of my head, I know there was a lot of back and forth between Mr. Noll and the officer, when the officer would say, you know, I smell marijuana, and Mr. Noll would say, you know, I don't use it, and the officer's, I hear that all the time, I smell marijuana. So to the extent there's a specific question of when is the last time you used marijuana, I'm not recalling that question off the top of my head.
Here's where I'm going with that. It seems to me, at least from my review of the video, that from the inception, this is a drug interdiction investigation. That's my sense of it. And then once drugs aren't found in the car, the stop is elongated for other search purposes.
I don't think officers are limited to one investigation. And so I do think that the officer had, at minimum, reasonable suspicion to believe that there would be marijuana, and certainly probable cause to believe that there'd be marijuana in the vehicle based on the smell of marijuana. So I do agree that the officer was, to some extent, investigating a controlled substance arrest, you know, a controlled substance issue. But I think that when we look at what the officer's testimony, too, at the motion to suppress about the manner of driving, those would be not necessarily inconsistent with a possession, but certainly more probative to an operating while intoxicated investigation.
Short time that you have left, can you respond to Mr. Knowles' argument that in the proceedings below, the state argued he was arrested for possession of methamphetamine, and so that you waived your argument on appeal to say that there is probable cause to arrest for OWI?
Yes. So the state raised this argument in its first responsive briefing in the first direct appeal. The appellant did not respond to an error preservation in that regard, and the court did specifically direct the district court to address the search incident to arrest question on remand. So while error preservation of a party, whether it's, you know, asserted or not, is not indicative, this court can of course find that error was not preserved or that an issue was waived on its own, even if not brought up by the party. But I think that the district court's remand to address that question in particular should quell any concern on that issue, given that that was essential to the remand.
Kind of a follow-up question on that. There's no published decisions on that DeVos line of cases as far as the state preserving error on a suppression issue. I know we have some unpublished cases from our court, but the Supreme Court hasn't spoken to that, have they?
That is my understanding as well. The state relies on the three cases that it cited, which is the Rave, the Bull, and I believe it was Jane's. The state asked that the court affirm the district court's denial of Mr. Noll's motion to suppress because the search was a valid incident to arrest and no evidence was found from the pat-down and it didn't prolong the mission of the stop. Thank you.
And Judge, just addressing briefly your comment about drug interdiction, if I recall correctly, Deputy Walker testified at the suppression hearing that he did not, at the time, have any training specific to drugs, narcotics, that sort of thing. So it would seem odd if he was out there specifically running drug interdiction. It was the state's burden to establish the applicability of an exception to the warrant requirement by a preponderance of the evidence. Warrantless exceptions are per se unreasonable unless they fall within a specific, narrow exception to the warrant requirement. So the search incident to arrest exception would have required them at the district court level to establish that there was a valid arrest for something. And the record does not establish that Deputy Walker was arresting Mr. Noll for anything before he searched him and found meth in his pocket. The state's claims are post hoc and speculative. It's, well, what if they could have arrested him for this? But it was their job to establish that that applied. As far as it being an OWI, I don't think he had a basis to think it was a drug OWI. Again, he had no training in drug stuff. He didn't have a basis to think it was an alcohol OWI. There was no testimony about the odor of alcohol. He didn't testify that the mumbling or the muttering, how he was talking, he believed that was consistent with intoxication or anything like that. And here, I don't think the beer can contributed to anything when the record shows that Mr. Noll affirmatively handed the can to Deputy Walker and allowed him to observe that it was empty. Beyond that, I don't think I've got anything more unless you guys have further questions. Thank you so much.
Consider State versus Noll submitted. I want to thank both counsel for your helpful arguments today and the good briefing in this case. And we'll have a written decision forthcoming as quickly as we can. And that adjourns the court for the morning.
All rise. Hearing, hearing, hearing. The Honorable Court of Appeals is adjourned.